Now, Erin, in your experience, when clients come to see you about parenting matters, what sort of questions are they usually asking?
When we see clients with parenting-related disputes, Matt, we do our best to try and negotiate an agreed solution to minimise the stress on everyone and, most importantly, the children. If matters are amicable and the parents are able to negotiate reasonably, then sometimes only a parenting plan is necessary. And that is a document that's simply signed and dated by both parents and dictates out what they've agreed. But whilst a parenting plan can provide details of what is agreed, it's not actually enforceable in a court, albeit it is actually a strong statement of intention of both of the parties should matters deteriorate down the track, particularly if it's been in place for a while. So, for example, if one parent decides to breach the agreement without a reasonable explanation and it's brought before the court in an application, the usual question will be from the magistrate, why isn't this working anymore? And if there isn't a reasonable response, then often the court will make orders in terms of the parenting plan.
Now, what if you think that they aren't going to stick to those arrangements?
Look, Matt, if you think that there'll be ongoing issues with compliance with the agreed arrangements, or if the arrangements are particularly complex, then we often suggest to clients that they obtain a court order in terms of what is agreed. Now, you can do this without heading to court. It's possible to file what's called a Form 11 application for consent orders in relation to both parenting and or financial matters for the purpose of obtaining a court order in terms of what you've agreed. And this is enforceable.
Okay, now we're going to move on to parental responsibility. What is it?
Parental responsibility is often an item that we'll encourage clients to include in any consent order. Parental responsibility is the responsibility for making long-term decisions regarding the kids, which might include religion, education, or long-term health decisions. What's important to remember, though, that if one party has sole parental responsibility, then they're able to make those important decisions without really any reference to the other parent, which might include enrolling the children in schools, preventing the school from allowing the other parent to collect the child. There's a number of different factors. It's also possible to make application for a passport for a child and in some cases change the children's name with only one parent's signature if you've got sole parental responsibility. So look, Matt, for these reasons, it's critical that if any orders sought by consent are put in place or proposed to any of your listeners, that they are properly reviewed by a lawyer prior to signing, in case you are potentially signing away your right to be involved in long-term parenting decisions.
Okay, what other things can be agreed in a parenting order?
Matt, you can pretty much agree anything you like in a parenting order except for child support. It's important to remember that the orders must be enforceable, so the more measurable and specific they are, the better they work. So apart from parental responsibility, often live-with arrangements, regular spend time arrangements can be formalised. You can also look at other factors such as handover arrangements, school holidays, special occasions, how the parents and the children are going to communicate, how each parent accesses medical and school information. There can also be requirements in there for each parent to keep the other updated regarding their email, mobile and residential address. In some cases, and actually unfortunately in many cases, it's important to have what we call non-denigration orders. And these are orders that restrict each of the parents from denigrating each other within earshot of the children or permitting anyone else to do so.
Now, Erin, do you need to define everything in an order?
Matt, the degree of prescription for each matter really depends on the parents. I often say to clients that the more you prescribe, the less flexibility you have. But equally, the less prescription you have, the more scope there is for different interpretations of what you've agreed. So in these circumstances, it can be really helpful to get a lawyer to help you craft a set of orders that gives you the right balance of prescription and flexibility so that you can co-parent in the best way possible.
Many questions are probably being raised throughout this segment, or if they want to find out how to lodge a Form 11 application, where can they go to talk to you?
Look, our website has a wealth of information, Matt, and that's found at dfl@dfl.com.au. Otherwise, your listeners could contact our office for an initial fixed fee consultation. We run them for $250 plus GST.
Yep.
So if they contact our office at 9443 1111, and our helpful staff will help them make an appointment.
Fantastic. Contact the team at Dimond Family Lawyers. Erin Dimond, many thanks for your time here on FIFO Live.
Thanks, Matt.
Back right after this, Red FM.